Hello, everyone. Hi, welcome. My name's Kara McDonald. I'm the Senior Director of Philanthropy and Plan Giving at the Seattle Public Library Foundation. We are proud to host this ongoing webinar series in partnership with our friends at the King County Library System Foundation. I want to wish you all a very happy August 1st. August is Make a Will Month. And based on how many people we had register for today's webinar, I think that means that making a will is on a lot of your minds, which is great. We have a wonderful speaker today who's going to help you get your ducks in a row and start making a plan. I know we also have friends joining us today from Snow Isle Libraries Foundation and Pierce County Library Foundation. So wherever you are joining us from, I hope you know how grateful we are that you support your public library. I have a few quick things before we let our speaker take it away. First, we are recording this session and you will receive a link to the recording and slides after we wrap up. Our speaker will be answering your questions today in live Q&A, maybe throughout, maybe at the end. We'll see how it goes. But if you have a question you want to ask of Mark, use the Q&A box and not the chat to ask those questions. That way we can make sure Mark will see it. And if you see a question that you would especially like answered in that Q&A box, use the little thumbs up button next to it to upvote it. Mark is going to be sorting the questions by your upvotes, so the ones with the most votes are what he'll be seeing first and what he can get to more quickly. And finally, when you sign off today, you'll be prompted to take a very short survey about your experience. So I hope you will take a few minutes to fill that out. It really does help us when we're planning for future webinars. And to sweeten the deal, everybody who takes the survey will be entered into a drawing to win fabulous raffle prizes, maybe like a bag of books. And now I'm going to invite our speaker, Mark Reinhardt, to join me on screen. There he is. Mark is an attorney and partner with Reberg Law Group. And if you've been participating in these webinars for a while, you might recall that Mark was one of our very early presenters in this series way back in 2021. We are thrilled to have him back with us today to share a wealth of knowledge in honor of Make a Will Month. So Mark, take it away.
All right. Well, thank you very much, Kara. So thank you everybody for making time on a beautiful, beautiful August day. Welcome to August, everybody. When I was young, one of my favorite times of the week, or maybe every 2 weeks, was actually when my mom would pile my brother and I into the car and we would all drive down to the library. So that's a long while back when we had no way to download anything or get it on screen. And of course, then we'd grab about as many books as we possibly could from the library and spend a couple weeks reading them. Fantastic time. So it's wonderful to be here in whatever way to partner with the libraries and to offer you more information as part of the library's ongoing efforts. Now, what's interesting is a few minutes before the session today, I happened to go online to both the Seattle Public Library and King County Library sites just to see what the history was. And I learned a few things. And the bottom line on that is the Seattle Public Library started in 1868. I was not around to give a seminar at that time, thankfully. And but one of the first books that was checked out apparently was Innocents Abroad by Mark Twain. And in a foreshadowing of today's or recent history, there was a disaster that occurred in the Seattle Public Library. 1901, the Yesler Mansion, where all the library's books were being stored, burned down. So you can imagine that caused a bit more problems than simply having website access interrupted for a while. King County Library, they started in 1942, so an ominous year right during the war. People wanted to make sure they got information available to them. And what I thought was amusing is that married women were not actually allowed to have their own public library card from the Seattle Public Library until 1970. So you think about what a long way we have come from those olden days. One of the interesting things about libraries is they are often known as the palaces of the people. And that's because they really offer us all a chance to educate ourselves, enlighten ourselves, have community, and these days even for entertainment. That said, that's not why you're here. You are here to talk about whether or not you should be doing a plan or what happens if you don't have a plan during life or death. So if we could go to the first slide, please, of the seminar. You will see a very handsome group there drinking their orange juice, trying to keep healthy. Today, we're really going to talk about it's an introduction to estate planning. So, of course, you'll understand that even though one of the things I'll be trying to do is answer some questions here and there. And again, remember to use the Q&A button and not the chat button. One of the things I'll be trying to do is just give that general introduction. We've got about an hour. And I've already thrown quite a few minutes into telling you histories of libraries. So we are probably going to be going at a pretty good clip. I'll try to get to those questions that I can, but please forgive me if we don't get to them all. And of course, like anything else, imagine if you were going to learn how to be a surgeon or even, a computer science major in an hour. Don't think you can take what we say today and simply go, oh, that's the answer. There's a lot of nuances that we won't, of course, have time to deal with. That's just kind of how these things go. All right, next slide, please. What are we going to talk about today? We're going to talk about basically 5 questions, tools, tips, tricks, and traps. What is estate planning? It's important we know what the heck it's for. Why do we do this sort of thing, especially on a beautiful day, even though it is National Make-A-Will Month? What's the best vehicle to administer my estate is the next topic we're going to look at. That's an odd phrase, and we'll explore that in a few minutes. And have I properly planned for the beneficiaries of my estate? Finally, a big one these days, the law keeps changing. Every time you go and think you have everything settled, things keep changing. So please know, right, even if you've got a plan together, if it's more than maybe 5 years old or so, it's probably a good idea to have a checkup. It's like what Mark Twain, not in Innocents Abroad, but in another phrasing, another place, he said, it's not what I don't know that gets me in trouble. It's what I do know that just ain't so. That's what gets me in trouble. So a lot of what we're going to be talking about today will probably be things like dispelling some myths, some beliefs that you may have had about things, and suddenly realizing, oh, wait a minute, I may not have understood that right. That's just not so. We'll have a few ways in which you can help yourself and your family and friends as well. All right, so let's then turn to the next big slide, that is estate planning. Well, actually, we think about estate planning as a situation where I need to have a will or I need to have a trust, but there's a reason we're doing those things. It's like, why do we have a car? Well, most of us, it's not just to have a car, as beautiful and as functional as it may be, but to get us from one place to the other, to take things that we have to go from one place to another. Estate planning is somewhat like that. There are 2 sort of control or features that we are really looking for. Anyone, why are we doing it, and what are we doing it for? The first one really is being in control. And that is that you're making sure that as long as possible, right? Even if you're around, you're picking out who are those people who are going to be helping you if you're not able to do something for yourself. And obviously, you want to make sure that after you're dead, you're trying to say, here's who's going to manage things. Here's my executor. It's called a personal representative today because the female executor is actually an executrix, which just sounds wrong. So we call it a personal representative. What happens and where do those assets go after you die? You are in control, not someone else, not the state. The second main purpose of doing estate planning is, of course, just having peace of mind, having that peace of mind about making sure that you know, hey, I got it put together, and I am trying to make sure that there won't be any conflict, there's no surprises, and much to my chagrin, many people want to minimize attorney expenses after they are gone. So those kinds of things would be why you would go ahead and engage in the process of doing your estate plan. So let's go to the next slide, please. Now we're going to take a little time out and we'll answer for the moment the top two questions. The question number one, do I recommend a transfer on death deed for passing of property? That depends. How's that for a great lawyer answer? Sometimes a transfer on death deed is a very good thing. For those who don't know what this is, it's sort of like a beneficiary designation that you can put on real property, on the physical deed itself. And it says, here's who gets the property after I'm dead. The problem with transfer on death deeds is it's very black and white. You put that on the deed, that person is going to get it if they're around. So you can't then go, oops, what if they die before you, right? Then you're not able to put another person as a contingent beneficiary, which you probably would be doing if you had a 401k or an IRA, for example. And sometimes transfer on death deeds don't work as well if that isn't really who you want it to go to forever. And we'll look at that in the context of a spouse. And if you leave a TOD deed to someone who's on government benefits or they're too young, then those things can also cause problems. So transfer on death deeds, they can help avoid a probate, and we'll look at what that means in a few minutes, but don't think that that is necessarily the worst thing that can happen. A probate in Washington State is not the worst thing that can happen. There are other mistakes that could be made. All right. So hopefully that's the first one. Then we've got a question on what should I expect to pay for a basic trust for a married couple? The answer is there's no such thing as a basic trust, and it really will depend on the attorney you're going to. There is sort of that penny wise and pound foolish sometimes. What you want to do is seek out the particular attorney and get kind of a here's the general range. Now, when I do this, here's the general range. Here's what happens. I give the low end of the range. And then when people come in and see me, they say, Mark, well, I want this and I want that. And I have a bunch of extra things I'd like as part of my trust. And all they remember is the low number I provided. And then if I give the high end of the range, people get panic stricken and think, oh my God, I can't possibly afford that. So the best way to do this is to provide information to the attorney and then decide. By the way, you said a trust, and part of a trust we're going to find out is making sure that you can fund it. And we'll look at what that means in a few minutes. That's part of the cost typically of a living trust. Now, let's look at the basics then of estate planning. So we're back on track. We're back to the slide in front of you. Estate planning is strategic. It's not just your will or your trust. We're going to talk about a will or a trust. What's the difference? What are the pros? What are the cons? But those are things generally, right, you're looking at as the big foundational parts. So you see that if we were looking at a clock face, this would be around, let's say, noon on that slide. If we go clockwise, the next type of document you'd want to have in your estate planning are called durable powers of attorney. These durable powers of attorney, there often are two. Generally, there'd be separate ones. One is for the finances, things that people need to have some tax, they need to take care of a tax issue or they need to get control of the finances to take care of you and your bills. The other one is a medical power of attorney or healthcare. And that healthcare power would be if you're not able to communicate at all to the doctors, then who can make medical decisions for you? Now, you want to generally be picking people, of course, that are going to work well in these particular areas. You want somebody maybe who's working in the finances, who's good with money and has time, is organized. Unfortunately, for healthcare, that may not be the same person. So you probably want to pick someone in healthcare who's got some healthcare knowledge or at least can serve as an advocate for you, someone who is going to be there making sure that you're taken care of and the doctors aren't just passing you by in the hallway, your room. They will come in because your healthcare agent is telling them, hey, you got to come in here and see this. The directive to physicians, if we go down on that clock face to about 4 p.m. or so, then that's often called the living will. The living will is going to say what you want done under end of life conditions. And there's generally two triggers. Trigger number one, that is if you're near death, so death is imminent, there's no real hope. Two doctors say nothing we can really do. Hours or days, you're gone. And others, right, the other trigger condition would be if you're brain dead or permanently unconscious. Some of you may remember that Terry Schiavo case from many years ago in Florida. A young woman became brain dead after a heart attack, and she was basically, not functioning. And the family was fighting for over a dozen years as to whether they should keep, treatments going and artificial hydration and nutrition, or whether they should have those withdrawn. So that's another document you would want to be making sure is part of your plan. The titling and transfer on death that we just kind of talked about, they should be coordinated. And that is going to be really critical, that these things aren't just haphazard. Many times I'll meet with people, I'll say, who is the beneficiary on your 401k? And they go, uh-oh, I'm not certain anymore. Or I name my spouse, but my spouse passed away. I don't remember who I put down. You want to have these things coordinated so that there's no surprises down the road. We're going to look, if we continue on the clock face, to estate tax planning. Unfortunately, the government believes that it has the right, duty, and obligation to tax estates for people who die with what the government feels is too much money, and the taxes on the quote privilege of transferring those assets. So we're going to look at that as well. And then who carries out the plan? Excuse me, that is obviously one of the things you're going to need to look at. We can have the best plan in the world, but just like any football team, if your quarterback is terrible, it doesn't matter that you have a great game plan. All right, let's go to the next slide, please, and I will see if we have any major questions. What's the difference between a will and a living trust? We're going to look at that in a few minutes. And when one spouse dies, does the remaining spouse have to pay estate tax? Or does that only happen with the death of the second spouse? I hope you're not looking at your spouse right now and with any malicious intent when you ask that question. The answer on that second question is there is a marital deduction between spouses. So in the normal course, there would be no estate tax when one spouse dies and they give everything to the surviving spouse. We are, however, unfortunately, going to be looking at some ways or reasons you may not want to do that. All right, so what's the best vehicle? We're back to the slides. What's the best vehicle to administer your estate? And the best vehicle to administer the estate is an odd question. But just like when you are taking you and your stuff to another location, suppose you're planning a vacation, you want to go to Southern California, right? Maybe you drive, but maybe you fly, but it's going to affect how you and your stuff get there. If you're going to Hawaii, you're certainly not driving. It's either a very long journey in a boat, or you're going to fly. Those vehicles take things from one place to another. And the law just has the same kind of idea. You have different choices for how you take your stuff from yourself to the next people you've named after you passed away. So let's look at some of those together. Let's have the next slide, please. Good work. Thank you. Option one is you do nothing. This is called intestacy. In simply means without, like inhospitable or inhumane. And testacy means testament. If you die without a last will and testament, here's what happens. And basically, Washington State has an intestacy statute that says, you know what? If you died and you didn't think about putting together a will or a trust or other documentation, we're going to say we know what you wanted to do. We have a plan for you. Generally speaking, the state statute will give your assets to your closest relatives. If you're married, your community property will go to your spouse. Then if you're not married, your property will go down in equal shares to your kids. If one's gone, it goes to his or her children, kind of down the chain in that way. If you don't have a spouse or kids, then the statute is going to look up and say, well, are your parents still living? And then the money would go to your parents. And then if there aren't any parents, it can go to brothers and then nephews and nieces, and then basically all the way up to grandparents if there's nobody down that line. So you can see there's this kind of like down, up to parents, down again, up to grandparents, down again. Obviously, you can end up with what's called the laughing heir problem, HEIR, not like what I'm missing up here. So HEIR, that is the laughing heir. They didn't know you well enough to cry at your funeral. They know the money well enough to laugh all the way to the bank. So there are a number of reasons why this statute doesn't work, not just that it may not reflect what you want. I had a couple come in, they've only been married for about a year. That means some things, some of their assets may not actually be community property. And they said, well, Mark, all our assets go directly to our surviving spouse, right? I said, no. If there's separate property and you have a wife and kids, right? Your kids from another marriage in this case, only 50% of your separate property is going to go to your spouse. The other 50% will go down to the kids. So that gave them some pause. If you have children or some beneficiary who's under 18, obviously that presents a bit of an issue because we can't give money to people who are under 18 without a lot of court involvement, having a court look over where everything goes and how it's spent over time. That means more attorney time. And of course, it means more money for the attorneys and the court. And it still requires probate. This is a shock many times, right? Probate, what's that? Probate is a court process. It technically is from the word probare, which means to prove. You're proving someone's estate. Probate, generally speaking, is time, effort, and money. And most of us get, right? That's what we need to do if there is no will, but that is only for the assets that are stuck in your name. So a number of you are asking things like, what happens if I would have a transfer on death, or what happens if I have beneficiary designations? Those things will pass by their terms, a beneficiary designation or a transfer on death. Unfortunately, many things like a house typically where you don't have a TOD or bank account or a brokerage account, many times they don't have any beneficiary designation, and those things will require a probate. Nice work on the next slide. Probate is a court process, and the main thing I want you to focus on is the number of little bullet points here. There's a lot more that couldn't fit on one slide, but you're going to see on the second bullet point on the left side of your screen where it says obtain letters testamentary. This is the reason why your executor has to go to probate, because your executor, your personal representative, they show up at the bank, the title company. Hey, I'm the executor. I need to get control of mom or dad's or whoever's assets. See, it says in paragraph 2AC that I am the executor. And the bank of the title company, they look at that and they go, yeah, we don't know if this is the right situation here or not. You're going to have to get some magic pieces of paper called letters. If there is no will, they'd be called letters of administration. If there is a will, it's letters testamentary, that same kind of word again. The basic idea is these are the magic pieces of paper that are needed. By and large, you can basically say, you know what, probate is not a whole lot of fun. Often when I'm meeting with people in a room, I doubt all of us would fit in most rooms together based on the number of people that are here. But I say, hey, how many of you have been through probate? And a number of hands will be raised. And then I say, okay, how many of you would want to go through a probate again? And nobody raises their hand. I've had maybe one or two clients in the last decade or two that say, "Hey, I enjoyed being an executor. It was a lot of fun, and I'm looking forward to doing that again." Let's go to the next slide, please. So probate, when we think about it, generally you want to think about probate, it's really three things. It's time. It's usually about a year to a year and a half to go through probate. It doesn't mean everything is sort of locked in place. Your personal representative can get control of things relatively quickly if things go well, but what they can't do is shut the probate down right before they've marched through all those steps that you saw on that previous slide. And then those things take time. The process is designed to kind of grind slowly and grind finely. And so generally speaking, it's about a year to a year and a half to go through it. The court says thou shalt do certain things at a certain time in a certain order in a certain way. And the result is you are grinding through that process and it takes time. It does cost money. Generally speaking, a probate is about 2 to 4% of whatever it has to be probated. There's no statutory fee. Unlike California, unlike New York and some other states, we don't say it has to be 8% of the first 100,000 and thus and such. But generally, attorneys will either charge hourly or a fixed fee, and they're kind of guessing how much difficulty, how much problems it might take. Now, that's in general, right? So here in King County, often it's maybe 7,500 to 10K, somewhere around there might be a typical probate of, the court fees, the attorney fees, publication fees, things like that. I was doing some estate planning in Selah, Washington. I don't know if a lot of you know where that is, just around the Yakima area. And I was talking with somebody that said, "Well, Mark, we just went through a probate here locally, and it didn't cost anything like 7,500 or 10K." I went, "Uh-oh, this is bad. I probably, right, big city attorney from Seattle. You go to Selah, Washington, it's probably a couple box tops, and maybe a $2 bill." And I said, "Well, how much did it cost here?" And the person responded, they said, "Well, we just went through a probate and the attorney's fees were about $50,000. $50,000? I had two questions. One, I said, "Well, can you tell me what happened? Was something unusual? Was there a lawsuit? Was it an unusual situation?" They're like, "No, no, it was all pretty smooth. There wasn't any lawsuit." And I asked the second question, which is, "How soon can I move to Yakima and the Selah area to practice law there? Because I would be retired by now." So a lot of it will depend on who's the attorney and I guess what they think they can charge. Of course, anything in a probate is also public, so keep that in mind. Next slide, please. Okay, so many people, right? This goes back to the TOD designation. Many people think, "Oh my God, probate, I got to avoid probate. I need to avoid probate. I'm going to do everything I can do to avoid probate." And yes, you can title things in such a way that you can often avoid probate, but there are mistakes that can be made. So what the first one is, sometimes people don't even know that something is not just going to pass automatically. And that is this first bullet point that says tenants in common. The reason that those won't pass automatically, even if it says husband and wife. So many times people will buy a new home and they will have it titled, and the escrow people will put it together. It'll say John and Mary Doe, comma, husband and wife. And I will talk with people that say, "Well, this is going to pass to the survivor of us." And I say, "No, unfortunately, it won't." That means you are tenants in common with that phrasing. You're both on the deed. It doesn't say any more than that. That means you each own half. And to many people's horror and astonishment, that means that a title company down the chain will likely need more proof as to how and why the first spouse that dies, half portion of the home goes to the survivor. So the tenants in common is often a mistake people make. They don't realize that could even be a probated asset. But many times people will, "Okay, Mark, I'm going to have a joint tenant with right of survivorship, a JTWROS Many of you may have bank accounts that are joint accounts. Many of you may have even real property. If you have a joint account or joint property, joint with right of survivorship, it'll go to the survivor. There can be some difficulties with that, however. If you say, I'm going to make everything joint with right of survivorship, you've now created an estate plan, at least as to that asset. But that means, let's suppose mom has two children, daughter and son, and daughter helps out with everything. So she says, I'm going to just add my daughter to my checking and my bank account. And based on Mark's discussion in that seminar I saw on August 1st, I'm going to go ahead and change the deed on my title of the property, and I'm going to add my daughter to that property as a joint owner. Okay, so now mom passes away. And of course, we use the joint with right of survivorship. And that unfortunately will mean everything goes to the surviving daughter. Son now doesn't have any part of that. Number one, we have an issue if daughter doesn't want to give half, right? Son's going, wait a minute, mom said we're supposed to be equal now. Where's my half? And daughter says, ooh, I'm sorry. I didn't realize that. I'll go ahead and give half the money to you. Well, now daughter has a gift tax problem. You can only give up to about 18,000 per person per year without having some gift tax complications. And now daughter is going to have to be filing Form 709. Daughter's going to have other issues as well, and potentially using up some of her estate tax exemption in order to give son what he was going to get otherwise. Suppose daughter gets the house and she's dribbling out a piece of the house at a time in order to try to work that gift tax problem and give things to her brother. The problem now is that what if she gets a divorce during that time? It's not like, her ex is going to say, oh, I understand half of that was supposed to be your brother's, son, daughter's husband and his attorney are going to fight for every dime of it. The same is true if there's a car accident. You'll be fighting to show how, well, that supposedly wasn't supposed to be mine. And the other issue is that mom was supposed to do a gift tax filing on her own if she was giving half the house to daughter, because that's what you're doing when you're adding somebody in as a joint with right of survivorship. So we can see this may be kind of using the wrong tool when all mom wanted to do was avoid probate. It's kind of using a hammer rather than a screwdriver when the hammer is going to cause some problems. And of course, beneficiary designations or transfer on death deeds can also, to a degree, have that same problem if you don't realize, wait, this means I am giving my assets away in an unequal fashion. You cannot just depend upon the next in line to give that away and make it all equal. Okay, let's go to the next slide and we'll stop for a breather and look at some questions. Let's see. Is there any way to keep the final distributions in my will flexible? The answer is yes. You want to have alternates. You can put in conditions. If my son dies before the second of my wife and I, then here's where the money goes. If my estate is more than a certain amount, here's where the money goes. My son gets a percentage of the estate, therefore, whether it's high or low, you can, right, make sure that everybody shares equally, depending upon where your estate is. And I've had some people that have even put in, if my estate is less than $2 million, then it all goes to my son. But if it's more than that, here's the amounts that can go to others, including charity. That is the primary reason to do good estate planning, is to have that flexibility. Okay. If I create a will with one of the online apps, but do not have two witnesses to sign it, don't do that. You need two witnesses here in Washington. Your will is going to be an empty piece of paper if you don't have a couple witnesses. There's some magic language that needs to be at the end of the will. A notary by themselves is not enough. A will requires two independent, meaning non-family members. you're going to have to kind of try to beg and hope that neighbors or somebody else will come by and be willing to execute that will with you, to watch you sign it. When you do the do-it-yourself plans, regrettably, that's where people often go wrong. They either don't understand what they've actually done because some of these wordings and the legalese is understandably mysterious to people. But the other problem is they make errors, simple errors in executing the document, and that's a disaster. So what you really don't want to do is be penny wise and pound foolish, because if you make a mistake, that generally means there's going to be a lawsuit down the road because people have a way of interpreting what you wanted to do in a way that favors them, and it often will lead to family members or others fighting. Okay, let's go back to the slides. Option number 3, community property agreements. Washington State allows us to put together community property agreements between a husband and wife or registered domestic partners. This it can avoid probate with husband and wife, right? When the first spouse dies for the Washington property, we transfer everything to the surviving spouse using that community property agreement. And it's sort of, there's some different documentation that can be put together to show the title company down the road or the bank of the title company, the brokerage institution. Here's how it all went to the survivor. You still need a will, of course, because you don't know who's going to die first, unless you're planning something, that you shouldn't be. You don't necessarily know who's going to, be the first spouse to die. And you have to be careful because the Washington Community Property Agreement only works for Washington property. If you're a resident here, those liquid accounts, right? The bank, the bank and the brokerage institution, things like that, those are considered Washington since you're a resident here. But for real property, those things would not work with a Washington Community Property Agreement. And real property can mean things like mineral rights in another state, that's land, essentially, under the land. It can mean timeshares that have a deed on them, or for many people, they just have a second home, right? We're going to live in Arizona, except the months where it's 120 degrees or over, and then we'll come back to Washington State. That used to be 2 months a year. Now it's about 8 months a year. So those things, right, you want to make sure of. And it's also not appropriate if you don't want everything to go to the survivor. Mark, you monster, I'm turning this seminar off right now. How dare you say that I don't want everything to go to my surviving spouse? What are you talking about? We love one another. We've given everything. We've been together for 50 years. That's the worst thing I've ever heard of. Well, the bottom line is, unfortunately, you got to be careful. There are some downsides with you giving everything to the surviving spouse with no strings attached. Number one, there could be a predator situation. That is, we do funny things in loneliness and in grief. One of the things we often do is we remarry. I help somebody with the probate, and then 2 years later, they call, Mark, I need to do a new document. Oh, what's going on? They say, well, I'm getting remarried. I say, well, congratulations. But then I start to learn maybe some of the details, and I think, okay, the new spouse, maybe they have their own kids. Maybe they have their own spending habits or drinking and driving habits, or maybe they just, right, have their own desires on what they're going to do with all of the money, because the survivor has all the money now. So we kiddingly call this the hunk or the bimbo problem, right? The remarriage, and you don't know if you're the first spouse to die where your assets, your half of things is going when the second spouse passes away. So that's one problem. Obviously, sometimes people get in accidents or car problems. There's an accident on the highway and, there's a lawsuit. If all the money is left with the surviving spouse, of course, it's all available to be taken in that lawsuit. But a main one is estate tax. Estate tax is a tax, as I said, on the privilege of leaving assets after you die. One of the people on the Q&A was smart enough to immediately ask me, Mark, is there a tax between spouses? The answer is no, right? That's the married card, the marital deduction. You're using when the first spouse dies, you're slapping a married card on the table and you're staring down the Department of Revenue in Washington State and the IRS. You're saying, I'm using the married card, no tax, go away. And they'll say, okay. But you know what they say? They say, we'll be back, kind of like Arnold Schwarzenegger, right? And when the second spouse dies, that's when they come knocking again. And the problem is, at least in Washington state and many times on the federal level, depending on what's done, the first spouse's get out of tax-free card was thrown away. What is a get out of tax-free card? What does that mean? It means each of us has an exemption. The government doesn't tax everything that passes after you die, only if you have over a certain amount. Think about it like a limbo bar, right? Anything under it, there's no tax. Anything over it, whoops, boing, there's a tax. The first, thing to know is Washington State, since 2006, has its own estate tax. The exemption is quite low. It's 2.193 million. You say, that's a weird number. Why is that such a weird number? Why not like an even number, like 2 million, something Mark could remember? The answer is because it used to rise with cost of living. It no longer does so. That is because they're using a technicality to avoid it rising with cost of inflation. And anything over that gets taxed. It starts at 10% and eventually it'll go up to 20%. So let's suppose you and your spouse, between all your assets, your home, your IRAs, your brokerage accounts, the cars, the jewelry, the couch, the coins under the couch cushion, and yes, your life insurance, the death benefit from your life insurance is all totaled up. That is your taxable estate. And when the survivor dies, if that's more than 2.193 million, anything above it gets taxed. The federal level, the federal exemption is currently very high. It is 13.61 million. Anything above that gets taxed at 40%. Unfortunately, that is going to be dropped about in half in automatically under current law on January 1st of 2026. So whatever you do, don't let your kids know that at the party for New Year's Eve in 2025. Hey, if I die tomorrow, there's a giant tax coming that might cause a little bit of a problem. So let's go to the next slide and look at the fourth option, number 4. Your will determines who your beneficiaries are. Okay, that makes sense. That's the whole point of putting together a will, is saying who's in charge, where do things go, and how. The will avoids a mess, therefore, right? We can pretty much say a lot of different things, have flexibility, make sure things pass without a lot of fighting. But what a will won't do is it will not avoid probate. What? Mark, what are you talking about? I thought that's why I have a will. A will, it avoids probate. The answer is no, it doesn't avoid probate. It avoids a mess because your name is still stuck on things. And your executor, even though they now have a will, see, it says right here, I'm the executor, they still have to go get those magic pieces of paper called letters testamentary in order to show that they are in charge. The other potential issue with the will is it won't protect you if there's a long-term incapacity. A will only springs to life when you die. But of course, if you have dementia, Alzheimer's, you're not dead yet, as the Monty Python saying would go. So you're still around. That means people are dependent. Remember way back when we talked about estate planning as strategic, that clock face, we talked about a durable general power for financial affairs. That's what your people, your friends, your family would need to depend on. But if that gets too old, it is not uncommon for that to be dishonored. That's why we say about every 5 years, you should strongly consider having your documents updated. Next slide, please. All right, well, there's a bunch of different factors here. If you want to decide whether or not you want to avoid probate, generally, if your will is drafted well, it's less of an issue. If you have a lot of different assets, it means it's harder. The real property, where is it? If it's in more than one state, it means you could have multiple probates, one in Arizona, one in Washington. Obviously, that's more expensive. The stinky relatives idea is just if you think people are going to sue. Obviously, if there's a probate, you have paid the money to open up a court forum and, have them cause problems at a relatively low cost. Who's the attorney just means you want to try to make sure it's not kind of someone who's usually not the general practitioner kind of person. You probably want to have someone who you are confident of that they focus in this area. So those are some factors of whether you care or not, whether you want to do a will. Next slide, please. Okay, so now we turn to revocable living trusts. And I think someone early on asked, what's it going to cost? You should know they are an alternative to wills and a probate. So whatever the living trust costs, you're kind of weighing it versus what am I paying now, which would be more than a will, but what am I paying later if there's no probate? Almost always that means a revocable living trust is going to be less. Okay, so how does that work? What is a living trust? Well, it's a legal entity, and it basically starts when you put it together. That's why it's called a living trust. That's when it's effective. It doesn't wait till after you're dead. It has people in it called a trustor. That's you. You're the trustor. You're the creator. That means you can change, amend it, or revoke it. That's why it's called a revocable trust. You are also, when you set it up, a trustee. That's the manager of the money, making the decisions. I'm going to invest it. I'm going to sell this house. I'm going to, buy a different property. You can do all that as trustee of your very own trust. While you're living, you are the only beneficiary, or with spouse, the beneficiaries of your living trust, which means, oh, okay, here we are. Right now, we're the trustees, we're the trustors, we're the beneficiaries. This is really for no one else while we are around. So that means we can have this very flexible. Obviously, you can change this from time to time, and after you're gone, it will manage to take things from your name, like a vehicle, your stuff, and take it to the next people you've named or entities without having to do a probate. All right, next slide, please. Now I'm going to stop and see if we've got a high upvote number of questions. Wow, what's the difference between a will and a living trust? We're answering that right now, so that worked really well. I appreciate that question. And if I create a will, we already did that one. Okay. Durable powers of attorney, should it be an outside professional or a family member? Generally speaking, I would say start with people in your circle of trust. Generally, that means a family member, a friend, right? If it is an institution, make sure they will serve as a power of attorney or an executor. You can use what I call an acronym. You want a superhero as to who serves as your executor or your financial power of attorney. You want them to have time, T for time. You want them to be honest, H for honest. You want them to be organized, right? They don't want stuff all over their house. They didn't file their taxes on time. That's O. And you want them to be responsible. If you say, Mark, right, I know they're going to do this because I've seen them do it. They're responsible. THOR, time, honest, organized, responsible. You have Thor. You have the superhero who is able to help you take care of those things. Almost always you want to start there because any institution, a law firm, a bank, a trust company, they charge a lot more money, and they'll typically do it every year. Okay, living trusts. We talked a lot about this. You can amend it. You can retain the same control. You need to just be aware if it's a revocable living trust, there aren't any different tax consequences while you are living. All right, next slide, please. Basically, this is what happens after you're gone. Your successor trustee, the people who are there operating after you're gone, you're dead, they are kind of handling the duties of an executor, but they can do this with paperwork they can put together outside of court, which means it's less time, less money, less effort, less, obviously, much more private. The downside with a trust is it's critical, it's fully funded, which means you have to look at the different assets and go, what is the best way to title them or to add a beneficiary designation? There is no repeat, no need to list all your assets in the trust document. In fact, you wouldn't want to. Why not? Because you don't want every time a bank changes its name, Umpqua and Columbia Bank or Washington Mutual or whatever it is, right? They change their name, they merge, they're gone, whatever happens. You don't want to have to amend your trust. What's important is how the account or the land is titled with the county of record or with that institution itself. That trust funding is what makes a trust work. The document is there to provide the instructions, but you have to make sure that those are already titled appropriately. Next slide, please. Okay, pros and cons. We kind of can work up on all of this, the pros and cons, and you can kind of look at this later. All of these things we've really focused on. But I don't want you to think, next slide, please, that a living trust is necessarily appropriate for everybody. About half my clients say, yeah, you know what? I don't really think a living trust is right for us. And I say, I agree. Generally, that's if they don't have any problems in the family. There's no fighting happening. Things are straightforward. When the probate is going to be easy, there's no land in more than one jurisdiction. A lot of times people have a very large amount of assets in a retirement account, like an IRA, and we wouldn't want those to go through a will or a trust anyway. So when you take those out, those all have beneficiary designations. There's only a house and a couple accounts left. Obviously, in those cases, a probate, a will is going to be a very, very good plan for them. But when things get more complicated, right, oftentimes that means it is better for you to have a living trust. All right, let's keep rolling along. I hope that answered the question on will versus trust. Have I properly planned for the beneficiaries of my estate? Let's go to the next slide. Planning for the surviving spouse. We talked a little bit about this earlier when we talked about the community property agreement. There is this kind of generally two ways we can go about it. Number one is what I call an I love you, honey plan. That generally means everything goes to the surviving spouse. I die, all to my spouse. We can use a community property agreement in Washington, as I mentioned, if that's the case, but then there aren't any of those protections from the creditors or the lawsuit, or most importantly, the estate tax. And obviously, if there's a blended family, you have kids from your prior relationship and they have kids from their prior relationship, we have a problem because this is a winner take all. The survivor could, once they get it all, change their will and say, I don't want it to go to my deceased spouse's kids. They never call, they never write. I haven't talked to them for years. So bottom line, maybe not always best. Generally right for younger couples or couples that have a, let's say, a modest amount of assets, generally best for people that families all get along and they don't need to really worry too much. That brings us then to, well, what's the option, Mark? Great, thanks. You put all this like cold water on my planning. Good work. What do we do then? Well, we can do something that I call an I love you, honey, but plan. And you'll notice the spelling, one T in but, right? I love you, honey, but planning. Instead of things going directly to the surviving spouse, the deceased side can go into a trust for the benefit of that spouse. For those that are watching at home, which is probably all of you, when you're off this screen, you can go look up a magic phrase. It's called a credit shelter trust. Credit shelter trust. And that credit shelter trust, the surviving spouse is usually the one you're putting in control. When I die, my portion of the assets goes into a credit shelter trust for the benefit of my spouse. They can use it for their benefit. That's that second bullet point on income and principal if they need it. And also, then whatever goes into that credit shelter trust now is not the surviving spouse's, even though they're in control of it, even though they get the benefit from it, it's not theirs. So that means they have protection against the predators, creditors, and most importantly, the estate taxes. We'll look at that more in a minute. But also, we get beneficiary protection because you can say whatever's left of the amount in the credit shelter trust that I gave to my spouse, when they die, it goes to my kids or my beneficiaries. Next slide, please. and that will help us learn a little bit more. This is the tax-wise will or trust. This is what I'm calling the I love you, honey, but plan. I'd suppose we've got Word in June. This kind of shows, right, my age and why I went to the library physically when I was a kid. Ward has 2 million. That's his community property part. June has 2 million, right? That's her community property half. If we do this I love you, honey, but plan, when Ward dies, and we know he's going to die first, A, because he's a man. Typically men die younger and they marry women who are younger, or often, right, one spouse dies. And the other issue is Ward smoked that pipe. So we know that can't be good for him these days. He dies first. His portion, instead of going directly to June, would instead go into a credit shelter trust for June's benefit. She gets the income, she gets the principal if she needs it, it's protected. Now, because we have done this, you'll notice his 2 million, he's using his own get out of tax-free card. He's not just leaving it directly to June, and then she is using the married deduction or the married card. We're using the get out of tax-free card. Ward's assets are under 2.193 million, which means there's no tax. Now, June trucks along. If she needs the money out of that trust, she can get it. She can get income from that trust. Her side's 2 million. She passes away just from general exasperation and irritation of dealing with the Beeve and Wally and Eddie Haskell or whatever happens, right? She dies. Her estate's under 2 million too. We've now saved approximately $250,000 in estate tax for the beneficiaries down the chain. So that's something that can be explored. I will say that most of those online programs that you might see or certainly would not offer this option for people. And remember, these numbers include things that you don't usually think about, like your IRAs, the value of your personal assets, and especially life insurance. All right, next slide, please. So we have different kinds of planning for children and grandchildren. Obviously, we have minors. If they're too young, we can't give them money directly. If you have your own minor children under 18, you got to make sure you have a will, because that's where the guardianship provisions, who takes care of the person of the child, that's where that goes. But you're also probably going to consider, you know what? I got to make sure that the right people are in charge of the money to take care of my child or a grandchild even, if they're too young, and they can use the money for their needs, things like education or maintenance or health or support. Then you pick an age generally, and you say when that younger person turns a certain age, that's when they can get control of the money. But before that, it's held and controlled and used for their benefit by someone you've chosen, older, wiser, more experienced. Manners means, that's that second main bullet point. Manners just means your kids are over 18, but you know what? They're really just not responsible. They never really went ahead and made their own life. Maybe they're still living in the basement and you're worried they don't really have the ability to handle the kind of money they're going to handle. You can have a trust for people who are over 18. You can have a trust for the same needs. You can say, here's someone else who's going to be in charge of it, and I'm going to have a trust till they're 50, or a lifetime trust. It's your money. You get to decide. Sometimes people say, well, I'm just worried my child will never actually do anything, right? If I give my grandchild money or a young person, will they just sit there and be a trust fund baby? And that can happen. So sometimes people will put incentive trusts in. And generally that is like, if they earn so much money, then here's how much money I will give to them. Or if they graduate college, here's how much is released from their trust. If they have a certain GPA, right? If they marry or whatever things you hope to promote in their lives, you can have that kind of incentive built in. And Minders is sort of sometimes people are under government benefits. Maybe they're on SSI, or maybe they're getting government benefits because of they have a particular handicap or need, or even you have a person who's on Medicaid, which is obviously for assistance with living for people who are older. Then you can go ahead and put in a what are called supplemental or special needs trust. If you just gave money to somebody on government benefits, generally speaking, those are assets tested, meaning if you have too much money, you don't qualify. So now you've given them 200,000, they no longer qualify for benefits, they're thrown off. They use up the 200,000, now they have to reapply. And in the meantime, probably the requirements have gotten harder. So a supplemental needs trust says don't spend it on things that young person or the person on benefits might have to use from government sources. Just supplement what they are doing. And sometimes people want dynasty trust, which is really those kinds of things that are for the long term. If you want to have a cabin and keep it with the kids for longer periods of time, or you just say, hey, I want to make sure this trust goes on and it's sort of a family bank for people for generations to come, that can be done. All right, so next, let's go to the next slide. You'll be thankful to know we are getting near the closeout of this. I told you an hour would go by really quick. Is your planning up to date, right? Wait a minute. What do you mean, Mark? I've got a trust. I've got a will. Wait a minute. Like the old judge in the Tammany Hall days said, whenever the legislature's in session, your life, your liberty, your property are not safe. So things change in the law. You may have planned for one set of laws and circumstances, but now there's another whole set that are here today in 2024. You have the Tax Cuts and Jobs Relief Act that was done in 2018, you may remember, but that sunsets as of 2026. That's why the federal estate tax exemption is coming down as of January 1st, 2026. It'll be about half of whatever it is, so probably around 7 million on the federal level. Washington's had, of course, a few changes in the last few years. Among the most principal are a Power of Attorney Act that really added a lot of different provisions to the powers of attorney that can be put in. Remember, you don't want those to probably be more than 5 years old anyway, because of that danger that an institution might not honor them. We had a Washington Trust Act, which talks about different kinds of reporting or accounting that will need to be done when your trust, your living trust, becomes irrevocable. Now, while you're living, it's revocable, but when you're dead, that's when it becomes irrevocable. Unless you are really got some magical powers, you're not going to be able to change it from the grave. It's now irrevocable. So this Washington Trust Act would come into play. HIPAA has become more important. Doctors want to see that privacy release before they'll give information to your healthcare power of attorney. And finally, it just may be that your family has changed, right? The kids used to be 12 and 17, and it's been 15 years. They could now easily act as my executors. They could easily get the money on their own because they're doing well. Those kinds of changes, or so-and-so's gone off the reservation, I haven't talked to them in 15 years, right? Those things can be changed. Next slide, please. All right, resources. Now this is with libraries. You know what? That's a great source of information. We don't all have to pile onto the internet or watch some attorney in a tie, right? Give us information. You have a wealth of resources available to you, and I dare say they're probably free. Amazing, right? How would I get a hold of these free resources, Mark? Why, very good question. You look on your library's catalog, the website, and you say, estate planning. Now, I know that the libraries will actually often have an entire page or two devoted to this, but here's some books that I've seen, and I thought they were pretty good. Get Your Ducks in a Row, or Estate Planning Smarts, or J.K. Lasser's New Rules. The Lasser book is pretty much updated frequently. Get Your Ducks in a Row is very new. The Estate Planning Smarts, it's a little bit of an older book, but I thought Ms. Jacobs does a really good job of explaining things. My wife and I were out at Port Townsend over the weekend, and they were giving away some books in an old store we went to. And one of them was an estate planning book from 1966. So, wow, okay. And I'm paging through it going, hey, you know what? A lot's different, but a lot's the same. So these older books, simply because they're not 2024, does not mean you really can't get some good basic understanding of the big picture. And then that's where the attorney or dare I say, there is an incredible YouTube star that probably has, oh, I don't know, maybe dozens of views. That would be yours truly. There is a YouTube video that it's about 13 minutes. So if at the end of this you go, oh my God, he talked too fast. I didn't get any of it down. I didn't hear it. You could, if you wanted to, go to that. I was younger, more handsome, had more hair, and much thinner, but it was still me. And you can kind of watch a 13-minute summary of a number of things we're going through. And also, our firm does have a website, and we, of course, have a number of resources available for that. Next slide, please. Okay, so there's sort of for us, I want to assure you, this is not designed for you to go, I need to talk to Mark and his team, right? It's for you to take stock and look at what's right for you. If you're on Whidbey Island, probably we're not going to be the best firm for you. But there's other reasons too, right? You have a friend, you have a buddy, you know some family members, you've got a financial planner. You find the resources that you think are best for you. That's the key. Okay, I'm going to answer a few more questions for maybe 4 or 5 more minutes before I am kicked off the stage. And oh, here we go. So, living trusts, are they state specific or can they cover several states? The answer is they can be in more than one state. You can have a trust based where you're a resident, and then that can hold property in more states. You live in Washington, you'll eventually move to Maryland. That's good for you. Unfortunately, you would want to have your Washington State trust looked at by a Maryland attorney. Maryland is, I believe, a common law state. We are a community property state. So the laws in each state can differ, but your trust would still be valid there. There's another question, are there assets that shouldn't go into a living trust? The answer is, oh, yes. Generally speaking, retirement accounts, IRAs, 401ks, 403bs, 457s, those should not go into a living trust. There's a few more nuances and rules, right? But be careful. You don't want to trigger any kind of negative tax consequence. Okay, what was that? I love you, Will. You can see I'm taking these at random now, right? What was the I love you, Will? That's that plan where everything goes to the surviving spouse in Washington with a community property agreement with the will. And it says first to die, everything to the survivor. Okay, let's see. Validity of the living trust executed some time ago outside of Washington State. It should still be valid. Unfortunately, how it's interpreted may cause a bit of an issue. One thing you want to look at in your living trust, and sometimes they will have that family trust, the credit shelter trust idea in it. The problem is if it's too old, especially if it's earlier than 2006, wow, they may have the wrong kind of tax provisions in the document, which would come up with some very unfortunate results. Okay, we have a question. I have a list of people who would act as DPA, durable power of attorney, or in the will executors. There's a hierarchy of names. You put down, if I cannot do this, then my daughter, right? My daughter Rose. If Rose is unable or unwilling, which sometimes happens, then it's my son Stephen. And if Stephen is unable or unwilling, then it's my cousin, Ephraim. Whatever it is, you can have people serve together as co-agents or co-trustees, but there is oftentimes a little bit more of a, planning that needs to happen from that. Question, are distributions from the trust taxable, like income tax? I assume this question deals with that amount of money that goes into the credit shelter trust and then income comes out to the surviving spouse. The answer is it's not a separate taxable event. The trust, when it's making income, right, that's still income taxable. But simply saying, I'm going to take principal or I'm getting the income out, that's not a separate taxable event. Okay, can you repeat how much a gift tax is? The answer is I can do that. Oh, you mean should I? Will I? 18,000 per person per year. Theoretically, that's right. Anyone you meet on the street, you give a check for $18,000 to. There's no gift tax consequences. You might be put away, your family would be concerned, but there won't be a gift tax issue. Remember, if you do that, though, it needs to be within the same calendar year. So people will make a check out to their son and they'll say, here's 18,000. They give it to them for Christmas. Everybody's on a holiday. Son comes back and cashes it on June 10th or January 10th. That's a different calendar year. And remember, too, it's all gifts. You take your child out for their birthday. You say, I'll pay for you to fly out and visit me. You say, I'm going to buy you a new bicycle for your birthday. Those are all part of the 18,000 per person per year. Okay, I'm going to follow up then with some real life estate planning examples. I apologize to those whom I didn't get a chance to answer the questions, but here's some real ones, and then we're going to turn it over, I believe, to Jessica. So here are 4 real life examples. Anthony Scott, in his last will and testament, said to my first wife, Sue, whom I always promised to mention in my will. Hello, Sue. Edith gave 50,000 to each of your children. Her will stated their inheritance was not to be spent on, quote, slow horses or fast women, and only a small amount on booze. Sarah Clark, in her will, said to my daughter, I leave the sum of $1 for the kindness and love she has never shown me. Finally, the German poet Heinrich Heine left all of his wealth, all of his assets, everything to his wife on the condition that she remarry. Because then he said, there will be at least one man to regret my death. Thank you very much for your time and attention. I appreciate it. And now I believe we're turning it over to Jessica to try to corral in this chaos that we've created.
Mark. Oh, thank you so very much. Oh my goodness. I'm Jessica Corso, and I am the Director of Donor Relations at the King County Library System Foundation. And I just want to say thank you, Mark. But also, I wish I could sit here and just share the chat with you, because there are so many people thanking you for an incredible, informative session today, your sense of humor, and the way that you've presented. So please know that there is a lot of love, and it's still coming in through the chat. So thank you so very much. This was huge. I do want to remind everyone, and I know we've answered this a few times in the chat, but it is one of our most popular questions, folks. We will be sending a follow-up email to everyone who has registered for the webinar, and you will receive a recording and the slides. And remember, the slide at the end had Mark's contact information, because I think there's a lot of you there who want to touch base. We also just want to remind everyone that at the end of this, when you hit exit for this webinar, you're going to go right into a very brief but really important survey for all of us. It is your responses to the surveys that bring people like Mark here to us, and they dedicate their time so that we can bring these informative panelists and topics to you all. So please take a few moments to do that survey. And there's always a little goodie at the end of it. So there's a raffle that we all do, and you may even receive some books from us if you take that survey. And finally, I do want to reiterate that it is Make a Will Month. So we wanted to kick off this Make a Will Month with Mark today and this session. And remember that Make a Will Month means that we hope that you will think about putting a little bit of your legacy giving and planning into a nonprofit. And we sure hope that might mean your local libraries. We also would love to know whether that is any of our libraries, systems that if you are or have already even indicated in your will that you've left, you're leaving something to a library, to one of our foundations. We'd love to know that. It's of course not necessary, but the reason we'd love to know if you are willing to share is because we can properly thank you, and we can also ensure that all documentation is proper, so that when your legacy, is left, we can surely make sure that it is put to proper use. Again, you will also see at the end of this slideshow, as soon as we pop off, all of our contact information is going to be on your screen. And so if there's any follow-up questions at all, please just reach out and let us know. We're always happy to answer any questions and get you information that you need. Thank you all for joining us. And again, thank you so very much, Mark, for your time and your efforts today. We really appreciate it.
Very much my pleasure. Thank you.
Bye-bye, everybody.